A split call, so we'll start with the Greens. Jan Logie.
Thank you, Mr. Speaker. It's my pleasure to take a very short call on this bill tonight, as our opposition was so clearly outlined by my colleague Julianne Genter just earlier. In fact, my speech will be quite brief and will act almost as an exclamation mark to hers. We oppose this bill for four fundamental reasons. One, we don't support legislation to correct the mismanagement of the order paper. Two, we believe victims should be at the heart of the justice system, including victims who may have committed crimes. And I would also like to note here that many of the prisoners in our prisons are people with significant disabilities, including learning disabilities and other types of disabilities. And to characterise them, as this bill does, as criminals who are a danger to society and acted entirely with ill intent, is to mischaracterise the nature of crime. Third point is that we do not believe the Crown should be protected from gross or actual any abuses of human rights, as this bill unintentionally will do. And fourthly, the state has a duty of care under international legislation, and that the only right a prisoner should lose is the right to liberty. These four fundamental reasons outline our opposition. Kia ora koutou.
Larissa Wall.
Kia ora, Mr. Speaker. Thank you very much. This is the first opportunity I have had to contribute to this debate. So this third reading of the Prisoners and Victims Claims 2012 Expiry and Application States Amendment Bill. I want to highlight that my colleagues Charles Chevelle and Honourable Leanne Dalzell were members of the Justice and Electoral Select Committee, and I thank them for the work they have done. I really just want to highlight points in three areas. The first really is about the importance of striking the balance between victims and offenders' rights. So what we do know is that the bill is before the House because the Department of Corrections in their recent history implemented an offender management system that was shown to be in breach of inmates' human rights and New Zealand's international obligations regarding our treatment of inmates and offenders. And we are also debating this issue because a judicial decision concerning the award of compensation to an inmate struck a chord of unease for politicians, decision makers, members of the general public, and more importantly, victims of criminal behaviours. So the second theme area that I wanted to highlight in this third reading is about addressing the concerns of victims and public perception. So at the heart of the Prisoners and Victims Claims Act 2005 was the concern that inmates, some of whom have committed terrible offences, would receive large monetary compensation for the abuse of their rights. But the Supreme Court decision in the Tanua case largely addressed this issue, and I want to highlight that my colleague Charles Chevelle spoke about this earlier. There was also a very real and valid concern that the victims of offences by some of those inmates who were and are carrying lifelong sentences themselves, lifelong scars that no monetary compensation could fix, were struggling themselves to obtain compensation from the inmates who had offended against them. And thirdly, I just want to highlight that there were questions of trust and fairness about that system. The only other point I want to make is really about the piecemeal approach to criminal justice legislation that I think this bill actually highlights. So today we are addressing two issues. Firstly, we are setting out the circumstances under which the judiciary can award inmates compensation for any breach of their rights while they are incarcerated. And secondly, we are trying to strike the balance between victims and offenders' rights, but setting out a process where if an inmate does receive compensation, the victims of those inmates can claim against any money they may be owed by that inmate. And so this is a very important issue that we're trying to fix. Labor is supporting this piece of legislation, but we should highlight that this could have been resolved 3.5 years ago. That's all I want to say. My final point is to support the comments made by my Labour colleagues during the first and second readings of this bill, and that is the need to think about the wider implication of offending by people who are not incarcerated in our prisons and those victims who are struggling to cope with the outcomes of the offences committed against them and to receive compensation from the offenders. And secondly, we need to consider the question of whether it is fair and appropriate that other forms of an offender's monetary or financial benefit should also be considered as an avenue to address the compensation issues for the victim. Kia ora.
Call Alfred Narrow.
Mr. Speaker, I'm proud to take the final call